Hello, thank you. I'm Justin. This talk will probably be a little bit different from some of the other ones we've had. I'm going to focus a lot more on privacy than on security. Also, I am not much of a technologist. I have a law policy background, but I'm going to be talking about a legal tool, a technical tool, which may potentially be helpful to solving a privacy problem which has vexed us and evaded being solved for decades. And what's the problem? What we read about in the newspapers every day, this website sharing my data with Google and Facebook. This app is sharing my geolocation with tons of third-party companies. Just yesterday, a European regulator found that the cookie consent dialogues, where you're ostensibly agreeing to share your data with tons of companies for real-time bidding, are illegal. This is what I think of as like one of the fundamental problems around privacy. I think primary use people kind of get. I share my data with Amazon to get a package. They process my credit card. They give it to FedEx. But that's all like in service of what I'm asking for. It's just other stuff, the sharing with other data brokers, monetizing my data. That's like I think one of the fundamental issues that regulators and practitioners have never really solved for. So the question is like, okay, how should we deal with it? What should we be doing? Well, first we could just not, which is largely how we've addressed it in the United States. That's obviously starting to change. There have been some self-regulatory approaches over the last 20, 30 years, but I don't think anyone would meaningfully argue that they've been enough. We had a little icon on most ads, but no one really clicks on those or even tries to manage the opt-out processes that the trade associations have. We could mandate opt-in. I think like a lot of privacy advocates traditionally said opt-in for everything. And then we saw the experience in Europe where every single website you go to, is it okay to use cookies? Yes, fine, leave me alone, get out of my way. And the companies have the ability to design those interfaces, and so we have a result that makes no one really happy. We could do opt-out. We could say, okay, the default's going to happen, but you have a chance to turn stuff off if you want. That's also super tedious. That's the approach we have here in California. You have to scroll under the CCPA, the new privacy law. You have the right to scroll to the bottom of a website, click, do not sell my personal information, deal with the user interface, figure out what to do, and then start all over with another website. So that's not really optimal either. You can just ban it. Oops, nope, not that. This is an approach I think privacy advocates have been kind of picking up on in recent years. Just say no. We're going to prohibit a lot of secondary uses. There's this whole ban surveillance advertising coalition. Let's just shut it down. Don't ask for my permission. Just end it. This is an approach that we've seen in some federal bills by Senator Brown. Buffy Wicks has a bill in California that would do this. We have a model bill that's largely based on this approach. And so I think this idea has some promise. Look, at the end of the day, you don't want to subvert free will. If someone really wants to share their data with the Lumascape and have targeted ads, that's totally fine. I just worry if we rely upon consent that like 90 times out of 100 or 99 times out of 100, it won't be really the volition of the consumer. They won't really understand what's going on. And so I think this idea of just banning stuff is interesting. We recently submitted a white paper to the Federal Trade Commission talking about how the FTC could maybe mandate this through existing law and say that websites can't ask you, can't bother you, can't torment you into agreeing to stuff or make it hard to opt out. But they should just prohibit a lot of secondary uses that people don't expect or don't want. So this is if you're interested in reading 40 pages on this on FTC legal theory, this is available to you. And so this is my preferred approach, is shutting down a lot of this stuff. But I think most of the regulators we talk to, like, well, this is a little scary. We're a little bit nervous about banning all secondary use. And so the place we retreat to is this idea of global opt-out. So, okay, if you're not going to shut it down by default, and we don't want you to torment everyone who goes to your website, maybe folks should be able to say, you know what, I just want out of this. I'm making an affirmative decision to just turn all this off. This is the idea behind the do not call registry, which did work for some time until people found ways to avoid it through VoIP IP address calling. But conceptually, if you're able to just broadcast, I want to be left alone, maybe that's a workable privacy approach. And so, like I said, a lot of regulators, the regulators we talked to have been scared to ban stuff or require consent. So they'll say, well, yeah, maybe an opt-out based approach like under the CCPA. Like I said, it's not really practical to do on a site-by-site basis. It's also very tedious, like cookie consent screens. And I think like a lot of privacy rights, or maybe are heterogeneous, like access and deletion rights. You probably you don't want to access everyone's data all at once. That would be overwhelming. You probably don't want to delete all your data from every service all at once. Like you might want to delete Spotify and tell them to get rid of your account because you're mad at them, but you don't want to delete all your frequent flyer miles or all your Amazon settings at once. But if you don't like your data being shared or sold, that's probably a universal sentiment. You want to be able to turn it all off at once. If you don't like the New York Times selling your data, you probably don't want ESPN or Fox News or anyone else selling your data too. So it makes sense that maybe there should be some sort of mechanism to turn this off all at once. And so this is the approach I've been working on for a couple of years. It's called the global privacy control. It's a way to configure your browser to kind of broadcast out with each web interaction, hey, don't sell or share my data. It started out as an extension that you can get for any browser store or any browser. Now some browsers have this pre-built in, so kind of more Brave and DuckDuckGo, which obviously differentiate on being privacy forward. Mozilla is starting to experiment putting this into nightly, and so you can just use these browsers to just broadcast while you're surfing the web a universal preference to be left alone. And so I think an analogy for this, I've seen this at some tech conferences that we're, once we started to come back from COVID, we all have our lanyards, we have various ribbons on them. There's a possibility of choosing a ribbon to designate how you want to physically interact with people. If you're like, I haven't seen anyone in years, give me a hug, I'm cool with it, that's like the green. If you want maybe more like elbow bump, that's some degree of intimacy that I'm comfortable with. But if you don't want anyone to touch you, right, you could just do this red one that says no touchy, right? And so you're broadcasting to everyone, I don't want any of this business. And that's like the sense behind the global privacy control, broadcasting to everyone, no touchy, or don't share my data. And so again, this is from the global privacy control site. You can turn it on. It does broadcast a signal to all the websites you go to with that particular browser. And it may have legal effects. And I'm going to talk about that in a second, but it may trigger legal consequences based on your sending it. This is a little bit about the organizations that are involved in this process. It was spearheaded by Ashkan Soltani, an independent researcher. He's now the executive director of the new California Privacy Protection Agency. There are other advocates like EFF in this group as well. Like I said, browsers like Mozilla, DuckDuckGo, Brave. There's also some publishers like the New York Times and the Washington Post, which are like, we've lost too much control over our advertising to these big tech intermediaries and want to kind of wrest control back over it to the publishers. I'm going to talk a little bit about some of the technical issues. I will not be able to answer any detailed questions about these, but like I said, it's sent in a header to every interaction and every forwarded request from your browser. And so this was detecting on my computer. I did not have it turned on, so it said the header was not present. It's also available in the DOM property. Same situation. I did not have it activated on this particular browser, so it's not detected. And then finally, there's a well-known resource where you can publish to the world whether you do adhere to or honor global privacy signals. And in this case, I was visiting the GPC site itself, and they broadcast out, yes, version 1, GPC is true. We do acknowledge and honor GPC requests. And so this is just it is on GitHub. It's available for comment. So we just processed some minor changes in the last week or so. If you have feedback, please feel free to visit it, make a pull request, provide a comment. Like I said, we are trying to evolve it, and we want it to be workable, both for companies and also easily usable by consumers. And so you may be thinking, this all sounds familiar. Have we tried this before? We have, in fact. Nope, I'll go back. We did spend several years trying to do this on Do Not Track. And this is an image from EFF's website. They also spent a lot of years trying to make it happen. A little bit on the history of that. And so this is an idea that was put forward by privacy groups in 2007. Again, around this time, privacy groups were more like, we want consent for everything, but if nothing else, like maybe we should be able to opt out all at once. The idea lay dormant for a couple of years until the chair of the FTC, John Leibowitz, was testifying before the Senate Commerce Committee. He's like, you know what, maybe we should do this Do Not Track idea. And that set into effect a flurry of activity. All the major browsers then put Do Not Track into their browsers. It was referred to W3C for standardization, started that process. There was a big event at the White House, I think in 2012 or so, where a lot of the ad tech companies showed up and said, you know what, we're going to do this. We're going to commit to honoring Do Not Track and fixing these problems which have annoyed consumers for years. And then things kind of went downhill from there. There was just no give. There wasn't enough reason for everyone to come to agreement. They couldn't even agree on a definition of the word tracking. They couldn't agree on what reasonable exceptions were. We couldn't really agree on much of everything. I think the biggest issue was that at the time when the big White House event happened, there was a real threat of legislation. Like Congress was considering a bill from Senators Kerry and McCain. The Obama White House had said, we support privacy legislation. And a lot of companies were like, we don't necessarily want that. But we will maybe self-regulate or adopt a more aggressive self-regulation than we've been willing to do in the past. Then the regulatory pressure kind of fell away. The Republicans retook the House, and Republicans are traditionally less interested in regulating privacy, though that's changing. Less interested in regulation in general, I think it's fair to say. And so the Snowden revelations in 2013 happened, so there's a lot more attention on government privacy and surveillance, and the Obama White House maybe looked hypocritical for pushing consumer privacy when the NSA was collecting cell phone records. And so the regulatory pressure went away, and then there was maybe less need or less incentive for a lot of the ad tech companies to come to agreement. Why agree to honor this thing? And so the process over several years, but definitely broke down and didn't happen. A lot of the browsers then pulled Do Not Track from the browser because it wasn't doing anything in the first place anyway. And so that was a sad story. So what's different now? Why bang your head against the wall and try to do it again? Well, for one, we have new laws. The California Consumer Privacy Act, the CCPA, passed in 2018, written very rapidly to forestall a ballot initiative on privacy. But it does offer legal rights that did not exist at the time of Do Not Track. So one, it gives you the right to opt out of the sale of your data. And they also say you can appoint someone to opt out for you because it's, again, like I said, it's tedious for you to individually opt out one by one. And then the California Attorney General was told to write regulations, kind of writing more detailed rules about this. And they said explicitly that user-enabled global privacy controls, like a plugin or a privacy setting or device setting, should be interpreted as a legally binding opt-out request. And so if you do broadcast through a global privacy control, that should be, in California at least, you taking advantage of your legal right to turn off the sale of your data. And then in January of last year, this is Attorney General Becerra tweeting out that the global privacy control, the GPC, should be considered and treated by companies as a legally binding opt-out in California. I think some companies were annoyed that this was major policy statements were done through a tweet, but since then the California AG's office has updated their website. In the FAQs, they say adherence to global privacy control is mandatory. They started sending out warning letters to companies, as they're required to do in California, saying if you don't change your policies and start changing your practices in response to GPC within 30 days, then there can be legal consequences. We haven't seen a lot of public enforcement. There haven't been fines based on it, but they have been sending out warning letters. And so we're seeing other states do the same thing, right? Colorado passed a privacy law last year. They explicitly talk about browser-based opt-outs. In California, Virginia has legal opt-out rights now. Don't talk about browsers, but like maybe this is a way to invoke those rights as well. And we're seeing tons of other legislation, Washington, Florida, Indiana, like Alaska. Most of the states are considering other legislation, and a lot of them, like most of them tend to be opt-out based, but more and more they include language around universal opt-outs through privacy signals. Okay, so does it work? This is a good question. I'm not really sure. Like I said, the California AG has said you have to do it, but I haven't seen a study, and I haven't tried to get a sense of how pervasive it is, like whether how many sites have a well-known resource stating adherence to it, which again is not necessarily mandatory. It's what you do with the data that legally matters. We do have a bot trying to crawl and get a sense of how many companies are doing it, but right now not really sure how widespread adoption is. One problem is that there are a lot of loopholes in CCPA. Like I said, it was written very quickly. This says you can opt out of the sale of your data. Is all the ad tech stuff really selling data? We've heard advertisers say, I have a cookie on my site. I'm giving Facebook data. I'm also giving them money to advertise. It's not really selling the data, is it? And so debates about the definition of sale. There's also language saying, you can share it with a service provider as an exception. And so some companies are saying, everyone's a service provider. We're all service providers. And that could be a way around it. A lot of these loopholes are changed or closed up in the CPRA, which is the new California privacy law that was enacted through a ballot initiative last year. And so we'll maybe see some companies who are claiming not to be bound by these rights. The rights will be a lot more expansive next year. Okay, so this is a cool potential toy. Right? Like I said, I would prefer something more aggressive, but if we're going to go opt-outs, maybe this is a way to kind of let people have some agency. Oh no, I don't want to update that. God, sorry. Okay. So there are a few limitations, right? So one is there are a lot of different laws, right? So there are 3 in effect, and that doesn't even count Nevada, which does actually have some privacy law as well. But there's tons more passing laws, and they're all a little bit different. And so something like GPC, which is universal, saying, hey, don't sell or share my data, should that count for each of these, which phrase their rights in slightly different ways? I mean, should you have to invoke? I'm invoking California law, right? Does that mean that GPC is not binding? Like I said, can California? Other states have not weighed in, and other states are still passing legislation. So it's going to probably be up to the enforcers in those states to decide whether a signal like GPC is enough to invoke your rights. Also, Europe's not on here, but Europe has in GDPR. There's a concept of legitimate interest where companies don't need to consent, but you can still object. And so, should GPC be considered an objection to that? I don't know. Again, we'll see. There's a lot happening in Europe on cookies right now, anyway. Okay, so what about Reoptin, right? What if the only effect of my turning on GPC is that now every website I go to is going to try to annoy me into ignoring it? And so this is not something I've seen in the wild, but this is based on something I saw in the wild. And you can imagine a shade on every site. We care about your privacy. Can we turn this off to support free content? And they favor the sounds good, thanks, make it bright blue. The alternative is update privacy settings, which sounds annoying, and then there's the very gray not now at the bottom, so designed clearly to get you to give consent. I think this would be a really sad and depressing outcome if this is what this is what GPC does. There are the law could forbid this, right? There is language in the Digital Services Act, which is a new legislation being considered in Europe, which would, if you have a global signal, would prevent them from tormenting you. There is language in CPRA, the new California law, that tries to encourage companies not to do this. The language is confusing, but this is a threat, and I think this would be a bad outcome for everyone, certainly for consumers. Okay, global, that's nice, but it's only like a browser. So how many global controls do you actually need? And this is a dated slide that I had used at a presentation in 2017 to the FTC on cross-device tracking. But the idea is that we have lots of different devices, right, and lots of different platforms. And so even on one computer, we use 3 or 4 browsers, and there are lots of other entities that can share data about us. Do I need to have a global privacy setting enabled for all these different devices and different user agents? And that maybe, it's 10 controls is still better than 1,000, right? And so it's an improvement, but do consumers have the ability to reasonably manage that? how many different signals are there, right? And so GPC, that's our signal, but you can imagine other entities kind of creating their own privacy signals. And so NOIB is a civil society organization, none of your business, based somewhere in Central Europe, and they're creating a similar signal. Do Not Track is out there still in some browsers. Interactive Advertising Bureau could create their own signal, and you can imagine like lots and lots of other signals developing. Plus, there are other signals on other devices, like limit ad tracking, and so on iOS. And so you can imagine, like, if you have 10, 15 different signals on 10, 15 different devices, and you're a company trying to do the right thing, this can seem overwhelming, and suddenly you get to descend into the multiverse of privacy signal madness. I think this is a legitimate concern. I think there is room for agreement between advocates and companies. Like, we don't want this, y'all don't want this, and so there is maybe some role for standardization to make it easy to comply. Two more, I'm running out of time, but loopholes. Like I said, there are a ton of loopholes in CCPA. While I think you should have the right to turn off a lot of secondary sharing and use, do you want to turn off everything? Some companies share data for security, which there are societal benefits to that. Some people talk about want to be maybe if you can't do targeted ads, at least we want to see what ads are effective. We want to track conversion. I think it's an open question. I can see arguments on both sides, but analytics, like if you want to use a company who's much better at analytics than you, maybe that should be okay, but then you're vulnerable to those same headlines saying, oh, this app is sharing data with Google. I think it's a tricky question about how to conform expectations and to conform what actually happens in the web to what people would reasonably expect. And then finally, like, what'll work? What if this works? What if this does actually turn off a lot of targeted ads? And you certainly see apocalyptic predictions about the internet burning down and free content no longer being available. There's another image I wanted to use for this, which is an old Far Side cartoon of two dogs, and there's a car flipped over next to them. And they're like, oh crap, we caught one. What do we do now? I think it's a fair concern. I think some of these concerns are overstated. We've only had this much behavioral targeting in very recent years. We had there was free content in the 2000s when behavioral targeting was much more narrow. We had small businesses back then. But there are concerns that these things, there will be less free content. There are concerns that I've heard raised with varying degrees of good faith that these sort of laws will might empower the big tech companies or make them only bigger and more powerful. Again, I think those are overstated, but I think we should be wide-eyed and aware of what might go wrong and what the consequences of these sorts of decisions will be. And that's it. Like I said, I'd love to hear comments on this. There is a GitHub. Feel free to reach out to me directly with thoughts and opinions. And hey, thank you very much for listening.